All rise, veuillez vous lever. The International Residual Mechanism for Criminal Tribunals is now in session. L'audience du mécanisme international appelé à exercer la fonction résiduelle des tribunaux pénaux est ouverte. Please be seated.
Interpreter's note, please switch off Mr. Kabuga's microphone. We can hear him cough. Thank you.
Well, good afternoon, everyone in the courtroom. I'm conducting this hearing from the mechanism premises in The Hague, and I am joined by Judge El-Baj and Judge de Guzman, who are participating via video conference link. Mr. Kabuga is also appearing today via video conference link, and it's been confirmed to me that he's receiving interpretation in Kinyarwanda. At the outset, I want to thank the parties for their flexibility in agreeing that this hearing could take place in September. There will also be some slight variations in the conduct of today's hearing, notably the fact that there will not be any live feed. However, this hearing is being recorded, and the recording will be available to the public shortly after the hearing, with public transcript to follow thereafter. I will now take the appearances for the parties. And first of all, for the prosecution, Mr. Elderkin, would you please identify who represents the prosecution today here and in Arusha?
Indeed. Good afternoon to all those present at the various locations. In Arusha today, there is Laurel Beg and myself, Rupert Elderkin. I believe in the Hague courtroom, we should have Kevin Hughes, Christine Keller, and our case manager, Dennis Turahan.
Thank you, Mr. Elderkin. And now Maître Altit, who represents the defense today.
Good morning, Your Honor. Good morning to all. With your permission, I would like to introduce to you our new legal assistant, Juliette. She is just sitting next to me, and I am Manuel Altit.
Welcome. In its decision of the 7th of August 2023, the Appeals Chamber instructed this chamber to expeditiously consider appropriate modalities and conditions for Mr. Kabuga's release. Since these proceedings were indefinitely stayed in September 2023, the trial chamber has worked tirelessly to comply with these instructions and is currently adjudicating Mr. Kabuga's fitness to travel and be released in Rwanda, with a decision expected to be issued in due course. With that in mind, today's hearing provides the trial chamber with another opportunity to hear directly from the defense on any progress it has made in identifying an appropriate and willing state for Mr. Kabuga's provisional release. The parties will also be permitted to raise any matters concerning Mr. Kabuga's health and detention towards the end of the hearing. In preparation for today's hearing, I held a case management meeting yesterday afternoon with the parties and the registry to try to focus today's discussion. So prior to hearing today from the parties, I will briefly update the public on the procedural developments since our last status conference, during which I provided general information on preliminary litigation with respect to the issue of whether the Republic of Rwanda, Mr. Kabuga's country of nationality, is an appropriate state of release for him. On 22nd April 2025, Dr. Gert Moerling, an expert in the field of critical care medicine and medical transfers, and who was appointed in January 2025, filed his report and concluded that from a medical point of view, Mr. Kabuga could not be declared generally fit to fly. On 2nd June 2025, the trial chamber issued an order in which it instructed Dr. Moerling to provide further information and clarifications in response to questions posed by the trial chamber. On 23rd June 2025, Dr. Moerling filed his supplementary report, confirming that while there is no specific examination that will show the risk level when flying, it is mainly his physical frailty, coexisting diseases, and medication, coupled with the length of the flight, that pose the greatest risk to Mr. Kabuga. While provided with the opportunity to file responses and replies to Mr. Moerling's supplementary report, neither party chose to do so. On 15th August 2025, the registrar filed the 7th monitoring report, in which the panel of three court-appointed independent experts provided their most recent joint opinion, confirming their previous views that Mr. Kabuga remains unfit to stand trial and to travel. The panel of experts also indicated in their report that Mr. Kabuga's physical and mental health have further deteriorated since their previous assessment in February. Between 15th August 2024 and 18th September 2025, the trial chamber also received a total of 14 medical reports from the medical officer of the United Nations Detention Unit regarding Mr. Kabuga's health. Additionally, in relation to efforts being undertaken by the defense to find an appropriate state of provisional release for Mr. Kabuga, the trial chamber issued a confidential decision on 22nd July 2025, in which it allowed the defense to share Mr. Kabuga's most recent medical reports with the relevant authorities and court of a specific state in support of a renewed application for his provisional release. On 9 September 2025, the prosecution also filed a submission in which it requests the trial chamber to decide whether to provisionally release Mr. Kabuga to Rwanda. The defense filed a response to this submission on 22nd September 25, in which it reiterated that releasing Mr. Kabuga in Rwanda is not an option based on the medical information currently on the record. In relation to this submission from the prosecution, I want to note that the trial chamber finds absolutely no utility in this filing, since it relates to requesting a decision on the question of fitness to fly, and more especially because both parties are aware that this issue is under consideration. To the extent that this submission is a motion, it is denied. The trial chamber does, however, note that in the final paragraph of its response, the defense makes a submission regarding a temporary solution that could take place in this case, while it continues to explore avenues in Europe for Mr. Kabuga's release. As this solution is not developed, it will not be entertained by the trial chamber at this stage. If the defense considers that this is in fact a viable option, in particular having regard to prior decisions of this chamber and by the President, it is free to substantiate it or any other avenues it deems appropriate in writing, and is encouraged to take all measures that may lead to a positive outcome in this case. Turning now to the recovery of legal aid funds provided by the mechanism for Mr. Kabuga's defence. I recall that on 4th March 2025, the registrar filed a confidential note verbal from a state authority that is believed to be the location of an institution holding adequate funds from which the full expenditure on legal aid could be recovered. This note verbal indicated that the state authority is conducting a thorough and coordinated analysis of the order for contribution, and in this regard requested additional materials and information to complete its analysis. On 29th April 2025, the registrar submitted 8 of the 10 requested filings and responded to questions by the state authorities. On the 1st of May, during the last status conference, the trial chamber granted the registrar's request for authorization to provide the relevant state authority with the 2 remaining confidential filings. The recovery of legal aid funds remains of crucial importance to this tribunal. I note that it is the intention of both the state in question and the registry, along with representatives of the trial chamber, to meet to discuss a way forward in recovering the funds owed by Mr. Kabuga. I was disappointed to learn that the meeting did not take place on the date originally envisaged. I encourage the registry to make every effort to ensure that this meeting happens.
Could Mr. Kabuga's microphone kindly be switched off? The interpreters are hearing a lot of noise. Thank you.
Has that been dealt with? Thank you. That now completes the procedural update, but I believe this is a suitable point at which to ask the registry representative with us today whether she could provide an update in relation to the recovery of the frozen assets, including possible anticipated steps to ensure that the technical meeting takes place as soon as practicable. Ms. Halm. Can you assist us further?
Thank you, Your Honour. Your Honours, on behalf of the Registrar, I can provide the following update on recent steps taken to secure the frozen assets. On the 4th of August, the authorities of the state concerned proposed indeed a technical meeting to take place in September between representatives of the mechanism and the representatives from the state concerned to review progress as well as to identify possible avenues for the implementation of the order. In response, on 11 August, the registrar proposed that the meeting be held on 8 September, noting that he would personally lead the delegation. The registrar also requested a separate high-level meeting. On 29 August, the authorities informed the registry that the high-level meeting could not take place on 8 September. They nevertheless indicated their willingness to arrange a high-level meeting as well as to host the proposed technical meeting. Your Honor.
Could you kindly speak into the microphone? Thank you very much.
I'm asked to invite you to speak into the microphone if you could.
Apologies.
Please don't worry that you're not speaking straight to me. Just do it in the way that's most comfortable for you.
Thank you, Your Honor. The authorities have not provided a formal explanation for the postponement beyond noting the unavailability of the appropriate high-level official. However, the registry was informally advised that prevailing political circumstances made it unlikely that a meeting could be held in September. At the same time, the authorities reaffirmed their commitment to hold the meeting, and the registry remains confident that it will be scheduled soon. The registry has no indication at this stage that the invitation to meet was anything other than genuine. The registrar continues to aim for high-level meetings to take place during the month of October. Please be assured, Your Honours, the the registrar and the registry remain firmly committed to advancing this matter and continue to apply pressure on the authorities, both at the working level and through formal channels. In this regard, the registrar is in the process of issuing a further note verbal to the state authorities in the coming days, reiterating the absolute institutional priority of the issue and requesting for a new date for the meeting to be confirmed as soon as possible. In sum, Your Honours, the registry considers that significant progress has been made and that further progress will be made soon. At the latest, by the next status conference, the registry firmly believes that there will be more clarity as to the resolution of this matter. Thank you, Your Honours.
Well, Ms. Halm, I'm pleased to hear that update because it undoubtedly advances matters beyond the stage of the Chamber's knowledge yesterday. So that's very helpful. One thing I'm not clear about from what you've just said is it one meeting that's proposed that involves both technical elements and a high-level representation, or is it two separate meetings that are envisaged?
Thank you, Your Honour. Indeed, two separate meetings are envisaged. A technical meeting at the working level, as well as separate high-level meetings between the registrar and the appropriate officials. Thank you.
Thank you very much, Ms. Halm. So that takes me neatly on to something that was also discussed during yesterday's meeting, in which I raised concerns about whether all organs of this institution were working together to recover this money expeditiously. I believe that one obstacle that may be prohibiting possible assistance from the prosecution is the fact that the trial chamber's order of contribution, which was filed on 2nd October 2024, included an annex that identified the relevant bank account that is currently the subject of the attempted recovery of funds, which was filed ex parte the prosecution. To rectify this issue, I'd like to hear whether the registry would have any issue with reclassifying this filing to confidential. Ms. Halm.
Thank you, Your Honour. The registry does not have any views on this issue and defers to your authority. Thank you.
Thank you very much. Well, in that event, the reclassification of the confidential and ex parte annex to the order for contribution will be confidential. Now turning to the question of provisional release. The defence has now filed 33 confidential progress reports on its efforts to secure Mr. Kabuga's provisional release. On 16 September 2025, the defence filed its latest progress report in which it informed the trial chamber of developments related to administrative proceedings that it is pursuing in 2 states, both of which initially refused to allow Mr. Kabuga to be provisionally released within their territory. Metraltit, now seems like an appropriate time to hear from you to update the trial chamber on your efforts to secure Mr. Kabuga's provisional release. I'd also be grateful if you could provide specific timeframes that you envisage for each ongoing procedure that's currently underway in both states that you're seeking provisional release, as well as information as to what, if any, other avenues you are investigating to move this issue forward. Metraltit. And I should say, we obviously prefer to remain in public session to the extent possible, but if necessary, we can go into private session to avoid disclosure of any sensitive or confidential information should you invite us to do so.
Thank you, Your Honor. Well, Your Honor, there are in 2 European countries proceedings that are underway, and they are moving forward, I would say, at a normal pace. Neither faster nor slower than the average procedure. So I'd like to give you some details, if I may. That being said, we've tried to speed things up. And we are hopeful that we are going to receive some useful elements, in particular in one of the 2 countries. And to be more specific, I'm afraid that we need to go into private session.
Session for this is, and please let us know as soon as it's possible to return to open session.
Your Honors, we're back in open session.
Thank you. Maître Article.
Merci, Monsieur.
Thank you, Your Honor. Now, Your Honor, regarding France, I should like to give you a brief summary of the situation. There was a ruling on the 1st of July 25 which rejected the application by Félicien Kabuga, considering that this application cannot be entertained by a private person, but that it is covered by diplomatic relations between the mechanism and the French authorities. The court considered that the refusal for the application of Félicien Kabuga, for him to come to the French territory, is what they call an act of government, and this is part of the diplomatic relationships between the French authorities and the mechanism. For the French expert who manages this procedure, such an approach leads us such an approach by the administrative court in France leads us to believe that this decision will be overturned in appeals, because in fact there is a discrepancy between the way in which the court viewed things and the reality being that there is an application by an individual, a private person who wants to be with his children, to spend his last time with them on the French territory, that this is so big that, according to him, the court can only overturn the decision. Now, the procedure is ongoing. The Appeals Administrative Court has requested the court to submit the filings and the case. And the next step is the request by the Ministry of Foreign Affairs, and potentially the reply by the Ministry of Interior. And for all of the proceedings, there will be the possibility for Félicien Kabuga to reply to the brief that will be filed, and the whole proceeding, to answer your question, may last about between 8 to 10 months.
That I think you said a moment ago that the file would be transferred to the appeal court or chamber. Did I not understand you at yesterday's meeting to say that that had already happened?
Vous avez tout à fait raison.
You're absolutely right, Your Honor. In fact, the application by the appeals court took place on the 2nd of September, and ever since the file was transferred.
Adequately covers the situation with the French application for the moment, or is there anything else you want to say on that one?
Monsieur le Président.
Your Honor, this covers the situation as things stand today in France.
We now return to private session, please.
We're back in open session, Your Honor. Thank you.
Thank you. Mr. Elderkin, is there anything you wish to add on this topic?
Your Honour, only very briefly, and I can do so entirely in open session. It's simply the observation that the efforts for Mr. Kabuga to be released in Europe don't need to be determined in advance of a decision on possible release to Rwanda. I think we've made many comments in the past in our written submissions and other status conferences, but I don't need to say more for now.
Thank you. Well, that completes, I think, the review of these ongoing proceedings. There's no more to be said on the matter, on that particular topic at this stage. But still under the heading, the general heading of provisional release, I turn now to the matter of Mr. Kabuga's fitness to fly. As I mentioned previously, the Chamber received the supplementary report of Dr. Merling on the 23rd of June of this year, as well as the most recent report from the panel of court-appointed experts on 15th August. The trial chamber is actively deliberating on this matter. So I will open the floor should either party have anything it wishes to say on this matter. But you will, of course, bear in mind in fact, the comment just made by Mr. Elderkin about the amount of briefing that's already taken place on the subject. Do you have anything to add, Mr. Elderkin?
Again, as you say, we can be brief. Our reading, I won't reference the detail of the report from Merling, which is still classified confidential, but just to say, we understand from what we have read and from other exploration we have done into the issue of aeromedical transfer is that risk mitigation can be applied. Air ambulances exist at various levels of sophistication, and accommodations can be made that would minimize, mitigate any risks associated with aeromedical transfer. For detailed discussion on this, I would first of all not be comfortable doing so in public session in front of a confidential document, but I believe it would be more effective anyway, done at a time when we can commit to writing our observations.
Thank you. Maître Altit, do you have anything further to say on this topic?
Oui, merci, Monsieur le Président.
Thank you, Your Honor. With respect to the transfer, things are very clear in our mind. We adhere to what the experts said. Now, with respect to the possibility of mitigating risks, that possibility that was just mentioned, well, the expert is very clear to mitigate risks is a theoretical approach which enables to reduce statistically the appearance of some symptoms and ailments, but this does not mean that the flight and that this transfer will be safe. Quite to the contrary, it has been underlined that the risks are there and they are very significant, especially because Mr. Kabuga is in a frail state. So it is absolutely not possible to transfer Mr. Kabuga. The expert is saying that, and he was very clear and very specific. He talked about also the mitigation of risks, and if he mentioned that, it is because he wanted to be thorough, but it does not mean that he does not say that a transfer is possible. When he talks about transfer, he talked about serious consequences, very serious consequences, and possibly fatal consequences.
Thank you, Maitre Altit. Now, I take it, in case I've misunderstood anything here, Mr. Elderkin, I take it you weren't inviting me to go into private session.
Your Honour, I believe that our position has been expressed clearly enough. That I don't have submissions on the detail. As I say, our view and reading from Dr. Merling is that risks can be mitigated, transfers can be tailored. I don't have more detail on the technicalities or the applicability to specific elements of Mr. Kabuga's condition. So I don't believe it would be useful at this status conference for me to say any more on that.
Well, thank you to both for your submissions on this topic. That takes me, I think, to the general point and one of the core reasons for having a status conference, and that's the current state of Mr. Kabuga's health in detention. First of all, Maitre Altit, are there any submissions you have to make concerning Mr. Kabuga's health and the circumstances of his detention?
Merci, Monsieur le Président.
Thank you, Your Honor. I would like to make a couple of comments. First of all, I believe that Mr. Kabuga is very well taken care of, and he has the best possible medical care. The second issue that I would like to raise is that in spite of this environment that is absolutely professional and helpful to him, he is showing a decline, a deterioration in his health that is noticeable. And I understand from the medical reports, whether the reports coming from the doctors, from the NDU or the independent experts, we see that there's a deterioration which makes his mobility very problematic, and it also plays a role on his mental state. So I believe that in this particular situation, I believe that the debate about the transfer should not take place. We should rather discuss, all of us, we should understand, and we should be aware that we are now at a different stage, as some experts are saying. So we have to be mindful of the fact that we have to think of things in a different way by taking into account the reality of his physical and mental state.
Well, I think I've already indicated to you that if there are significant submissions you wish to make about changes in circumstances, the way to do that is in writing, and not, I think, in this discussion here. This is, so far as health is concerned and detention, this is a forum in which to raise anything that can be expeditiously addressed by the trial chamber and needs to be dealt with urgently. Now that completes the formal agenda. Is there any other item of business that either party wishes to raise? Mr. Elderkin?
No, Your Honour.
Thank you. Maitre Altit?
No, thank you very much, Your Honor.
Well, I thank you both again for the very helpful way in which you have conducted not only today's proceedings but the meetings we have had in preparation for this. However, before adjourning these proceedings, I would like to emphasize that the trial chamber continues its efforts to expeditiously implement the appeals chamber's instruction to find an appropriate state for Mr. Kabuga's release. While the chamber has endeavoured to find a viable solution in consultation with the parties and the registry, it's worth noting that as of the date of this hearing today, Mr. Kabuga has been in detention awaiting provisional release for more than 2 years. As I have previously stated, finding a solution to this issue continues to prove extremely challenging, especially as the trial chamber faces unprecedented difficulties with respect to Mr. Kabuga's deteriorating medical condition and an unwillingness from certain European states to accept him on their territory. On entirely different subjects, I've also been informed, Mr. Elderkin, that Mr. Rashid will shortly be leaving the mechanism. And as he will no longer be working in this case, I wish to convey the appreciation of the trial chamber for the cooperative and congenial manner which always characterized his appearances before and dealings with the trial chamber and with the defense. I understand he'll take some time off work on his golf game, and all I can say is that the most important shot in golf is always the next one. And I sincerely hope that he will find stimulation and fulfillment in whatever he decides to tackle next. So please convey these remarks to him on behalf of the chamber. And finally, this will be the last time a trial chamber sits in courtroom 1 of this mechanism and previously the tribunal. It is also the last time this storied and historic courtroom will be used. Hundreds of people have sat in these chairs and within these walls over the decades the institutions have been in existence. Judges, counsel, witnesses, courtroom and technical support staff, interpreters, security and accused, all in pursuit of justice, fairness and truth. We'll be the last. This is an important moment, and let's all appreciate how fortunate we are to have had the opportunity to work here. But fear not, alternative arrangements have been made by the registry for court activity in a modified conference room. It may not be as impressive as this courtroom, but all the essentials will be there. After all, a court is at its heart simply a forum where arguments are exchanged, evidence is heard, and decisions are made. I look forward to seeing how our new venue for these hearings will look, and until that time comes, this hearing is now adjourned. Thank you for your assistance.
All rise, veuillez vous lever.